As a court, as a highest court, we have authority. But we can only maintain the trust of those seeking our help if our judgments are factually correct, legally sound, sensible, and fair. And to be able to rule on the facts in complex disputes, we as judges need experts, subject experts. But who is a subject expert? And how can a court tell? The judge's problem is precisely that, and he has no way of assessing this. The Netherlands does not have a tradition that expertise needs to be proved. We do not require experts to explain their expertise when they are heard as expert witnesses in court. And neither do they have to account themselves in expert reports. This is totally different, for example, from the United States of America. I once witnessed the examination of an expert, a pathologist, in a capital murder case, the New York capital of the New York Criminal Courts building. And she was examined for more than 50 minutes only on her expertise before being permitted to make any statements about the case itself. In the Netherlands, the tone of the exchanges in court are hardening. And in the administrative courts, we now also see experts being challenged on their expertise. And sometimes party A challenges the expertise, or the lack of expertise, on the expert called in by party B. And it's therefore the Council of State is in a fortunate position that we can call on the STEP Foundation and ask them to evaluate the reports of the parties' respective experts in terms of their factual accuracy and, when disputed, the research methods used. And sometimes we can also ask them to inform the court whether one party's expert has anything useful to say about the subject. In other words, whether the expert can in fact be seen as an expert at all. Disputes which go to court are about the facts in more than 90% of the cases. Medical errors, technical faults, radiation risks, the chances of an earthquake. Maybe you know that in the north of Holland we suffer from earthquakes at this time. The significance of medical problems for someone's driving skills, etc., etc. And the courts are asked to decide on the most complex of factual disputes. And as I already stated, the problem is that a judge is not a subject expert. The parties can call in experts, but the court cannot assess the accuracy of the experts' reports. The only thing that a judge can do, if the report is at all in the kind of language which can be interpreted by someone with a simple but good legal background, is try to assess whether it is logical, whether it is comprehensible, and whether it is conclusive. Within the Council of State, we deal with administrative law. And one of the characteristics of the procedure is that one of the parties is always the government body, an administrative authority. And if a government body has called in an expert, the administrative court must confirm whether that body has verified the soundness of the report from the expert. And if a claimant, an appellant, a plaintiff, or whatever we call them, can submit no or insufficient defense to contradict the government body report, then the game is often over. But, on the other hand, if the claimant also calls in an expert, and if the court is unsure which expert is right, then the court may call in its own third expert. And precisely because a judge has no subject expertise, he will be inclined to listen most to his own expert. And that mechanism is only acceptable if the expert called in by the court meets certain requirements. And that raises an interesting question. How does a court know whether it's dealing with a truly reliable expert? My question to you is, what does a reliable expert look like? I'll show you this picture. What do we think of this guy? Let me put it another way. How many of you are experts? Please raise your hand if you're a court expert yourself. How many of you that have raised your hand have a Labrador dog? One. That's good to hear. Do you also have a hand-knitted Norwegian cardigan? No, you don't? No, you don't. Why do I tell you this? Studies have shown that people are more likely to trust a person if he wears a hand-knitted Norwegian cardigan or someone with a Labrador. And that's heartwarming, of course, but it doesn't exactly help a court find a reliable expert. And yet it is extremely important that a court can trust the expert's expertise, and it must, after all, be able to base its conclusions on the facts presented by that same expert. And it is therefore in the public interest, in the interest of public health, animal welfare, nuclear and food safety, the environment, access to basic rights, asylum, benefits, whatever, that those factual conclusions are state of the art. Greater expertise means a better grasp of the facts, and therefore accurate facts to support the court's decisions. And as judges, we attach great importance to the facts. We are not about fake news. And that in its turn promotes greater confidence in judges and the courts and in the system of rule of law. So let me turn to the requirements for court experts. What are the basic requirements for a court expert? A court expert must be impartial, be independent, he must conduct a thorough investigation, and his integrity must be beyond question. He must also be a subject expert with proven knowledge and experience in his field. A court expert must also have at least a working knowledge of the court procedure. He must be able to understand the framework, legal and otherwise, within which the court requires his expertise. A court expert must also learn how to report to a court. And as you know, this is quite different from presenting facts to fellow experts, peer to peer. The expert must be able to account for the facts he presents, and for the sources and in the investigation methods he uses. And his findings must be presented in a verifiable manner, so that it is possible to examine them in the light of the evidence of the country. He must formulate his findings in a comprehensible way, which also means plain language, otherwise judges can't understand it. And finally, he must help the court by ensuring that his findings focus on the facts relevant for answering the legal questions to be responded by the court. How do we try to solve this problem in the Netherlands? It's difficult or even impossible for a court to verify whether an expert meets all these requirements. And that's why the courts use various registers with reliable information on experts who meet those requirements. And the Netherlands have a number of expert registers, some government financed and some privately funded. I mentioned a few of them. For criminal law, there's a special register, the NRGD, the Netherlands Register for Forensic Experts. And this register is government financed. If a criminal court and the judge in the criminal court wishes to call on an expert, it must select someone from that register or explain why an unregistered expert should be called in. Then we have a special register, the DOBS, for experts on expropriation. We have a special, well, not a register, but a foundation, the Dutch Society on Medical Specialistic Reports, for medical specialists with extra expertise on legal issues. And as Sasha told us, the administrative courts can call on the STAP Foundation for advice on matters on environmental law. And then, it's the last register I will mention, we have the LRGD, the Nationwide Register for Forensic Experts, which is a register on experts in every field, criminal, civil and administrative matters. And the LRGD is privately funded. This register has no quality checks of its own, such as the Register for Experts on Criminal Law, and they work with a different approach. Their members must meet the requirements laid down by their own professional organizations. Let me continue with the approach of the Council of State. What is our approach? As a court, we have no legal obligation to appoint experts from a specific register. In other words, we can choose. We can choose freely. But that doesn't mean that there are no requirements. From February 2018, we have our own code of conduct for forensic experts. And it is published in the State Courier, the government gazette. More than 95% of the experts we appoint are experts in the field of environmental law. And they work all for the STEP Foundation and they all qualify. If we need medical experts, we can rely on the NVMSR. Most of their experts are registered in the LRGD register. And if the STEP Foundation and the LRGD cannot help us out because we are in need of specific fields of interest, sometimes a document analyst, for example in a passport fraud case, or nautical experts, we search for reliable experts ourselves. And when we have found an expert who's willing to work for the court, we use our own disclosure statement. And what we sort of hope for is that with our own requirements, we set a standard. Maybe someday the standard for the parties' own experts. It's too early to tell. We have to wait and see if our code of conduct and our disclosure statement have any external effect. So let me tell you a little bit about the code of conduct and the disclosure statement. As I just mentioned, the Council of State has its own code of conduct for experts. This is not the time, it's not the place to discuss the entire code. But it includes provisions on the expert himself, the service to be provided to the court, on-the-spot investigations, the contact with third parties, contact with parties themselves, the effectiveness of the investigation, the costs of the investigation and the report itself. As stated, the Council of State also uses a disclosure statement for experts. Experts that are not on an official register. Let's see. Our disclosure statement consists of two parts, two sections. In the first general section, the expert is required to provide information on his profession, qualifications, the number of years of proven expertise in this field, if he or she is a member of a professional organization, when he was registered as an expert, whether he has been re-registered, whether he or she keeps up with continuing education, whether the expert is subject to a complaints procedure, and whether he is subject to a professional disciplinary code. In the second, the more case-specific section of the disclosure statement, the expert must provide information on his impartiality. Does he have any interest in either one of the parties in the case or the outcome of the case? And does he have the specific expertise required to answer the questions of the judge, the court? And if the expert submits a report, he is then required to provide information on his findings of the facts, his investigation methods and the sources he used, his findings in the light of the questions of the court put to him, and any other relevant case-specific matters. Ladies and gentlemen, I'd like to wind up. I've tried to explain how the Dutch courts find experts and find expertise, how we use public and private registers, how we use registers, codes of conduct and disclosure statements. Our methods here in the Netherlands are not unique and are replicated in many other countries. So what is the bottom line? At the end of the day, we try to ensure that a court is informed of the facts in a reliable, verifiable and comprehensible manner so that it can reach a well-balanced conclusion. Conclusions which promote the legal system because they are based on subject expertise and which help maintain public trust in the courts and the administration of justice. And I believe that is in keeping with the goals of the EEEI. I hope, ladies and gentlemen, that my introduction has provided a modest contribution to what you think is important, and that's redefining the expert's role and place in our society and harmonizing professional practices and rules. But aside from this, I believe that the mere fact that the key stakeholders, judicial experts, magistrates, lawyers, academics, are meeting here in this very place today to exchange ideas on the importance of expertise and experts before proceedings is an excellent initiative of the EEEI. I wish you all a very interesting morning, and I thank you for your attention.